Can Playdates supplement distant learning during COVID-19? As we've talked about in previous blogs and YouTube videos in the past few weeks, and as schools across the province have resumed, this time of year often brings many urgent motions to the court by separated parents who are at odds over whether their children will attend school in the fall. In light of the new challenges arising from the COVID-19 pandemic, including the controversy over in-person versus remote learning, the degree of fine-tuning this issue has been noteworthy. The law continues to develop and clarified incrementally as the courts hear individual cases, many featuring innovative arguments on either side of the debate. In a recent case, the court was asked to reflect on one of these narrow issues. In support of one parent's bid for at-home rather than in-class learning, to schedule play dates with enough friends give the child enough opportunity to develop social skills? That was the question. The separated parents who had joint decision-making authority over their 6-year-old child disagreed over whether she should return to in-person learning or else be enrolled in an online learning program made necessary by COVID-19. The child had been attending school until March 2020, when the provincial government mandated the closure of physical schools in favor of online education. Now that her school had reopened in September 2020, the parents were offered the choice of whether to send her back to classes or continue with online studies. The mother wanted the child to return to the classroom. The father wanted her to stay at home. Under the father's plan, he offered to arrange play dates with some of the child's friends, as a means of ensuring the child's social skills continued to develop. After looking at a number of factors, the court ruled that it was in the best interest of the child that she return to in-person classes. It acknowledged that the child would accordingly face some risk of exposure to COVID-19, but concluded she would benefit from being with teachers and peers, and importantly, would continue to develop her social skills in that environment. On the specific issue of whether the planned play date should suffice for the child's social development, the court complained that the father's proposal lacked specificity. He did not indicate how often the child would see her peers or how many might be involved. Also, once school had resumed and the friends had returned to their chosen learning environments, the opportunity for play dates would be more limited in any case. Plus, the father had tendered no evidence that he had spoken with the families of the children's friends to determine their willingness to have regular play dates after school or after the school year had started. Finally, the court pointed out that the father's playdate plan appeared to involve mainly other children who had all returned to in-person learning. This actually created another potential risk of COVID-19 exposure for the child, which had the overall factored into the overall best interest of the child equation that guided these determinations. Against the backdrop of these particular facts, the court ruled that was not satisfied with the occasional play dates and that they can meet the needs of the child with peers over an undetermined period of time until the pandemic comes under control. So what do you think? Did the court get the case right? Comment below in our comment box. You can like and share this video. Hit the bell to subscribe to upcoming videos. Stay safe and thank you for watching today. Until next time. I'm Russell Alexander.